was done after sunset, before sunrise. Then on that ground, Your Lordship, I have argued that they have not given the reasons in recording that this was done so during that period of time and the reasons why they have done it. And this was the reason. Secondly, Your Lordship, on the last occasion, Your Lordship is party ordered. Your Lordship, last two occasions, in fact, Your Lordship has directed them to produce the copy of the authority letter, which they said that there was an authority letter with regard to the search and seizure, which I have also objected to that, because that authority letter was nothing to do with the search and seizure. It was an authority letter with regard to the team that was made for the raid. It was not with regard to the search and seizure. Now, on the last occasion in the records, that letter was not found. Then Your Lordship has directed my learned friend to take instructions whether that letter is available or not. In fact, in the CD, it is not available. And rest, Your Lordship, my learned friend says that as per what he told me, that he has taken instructions from the OC
No,
concerned.
what is your main plea?
My-
Plea is that the reasons for conducting search after sunset were not mentioned.
Yes, that was
So,
not
If
mentioned.
it is not mentioned, then that is violation of 42.
That is why. That is what my main case was.
So what is the law? If the 42 is violated,
The
you
mandatory
get-
law. That is why I have given all the judgments here.
you have given the judgment.
Yes, all the judgments. The law that it is mandatory. And secondly, Your Lordship has also asked me that on that day, when the first Your Lordship has heard the matter, on that day, Your Lordship has asked me, yes, if it is a law, fine, but whether bail can be granted or not, then I have given two other judgments where the Honorable Supreme Court has said if there is a violation of Section 42 of NDPS Act, it's a mandatory provision, and in that case, bail must be granted.
Which judgment?
That all the judgments I have already given to Your Lordship. Just a moment, there are many judgments I have given.
Okay.
Lordship, we made the
Okay,
inquiry.
you go through the record. Our court record.
Court record, they have gone through, Your Lordship. It
No,
is
no,
not
for
available.
your judgments. I'm not.
Oh, okay.
If it is there, you make it systematic in systemized way.
Okay.
And on the top of the judgment, you may write which relevant paragraph.
Okay. Actually, I have given, I think it was, Your Lordship, it have you also written it. I don't know if it is there or not. That
No,
is why I'm not actually
no,
arguing.
it may be there. It may be there.
I'll
but
do it. I'll do that.
you-
I'll do that.
I'm-
Only thing, Your Lordship, only that part. I had to.
Whether you could find anything.
Lordship, we made the inquiry with the concerned police station in this regard. So OC has stated that the IO who is in this particular matter, he was on leave. And so he prayed for a short time because they tried to search it out, but they didn't find anything.
No, what is required? You
Required is only that part only, Lordship. That is the section 42.
whether there was
Any authority letter issued for the
For
purpose of
conducting
search
search
after sunset.
after sunset
After sunset.
and whether anywhere any reason has been mentioned
Yes.
for conducting search
Yes. sir.
after sunset. That is the mandate. That is what is the submission.
Yes, nice.
Yes.
So when can you?
What's the short date? Because I asked
Because-
them because I was leave. They have only stated they pray for a short.
By that time, you can give the.
I'll do
judgment.
one thing. Today, all the judgments are there. I'll mark the judgments today itself.
Yes.
On the next day, if he produces his
Yes.
produces, I'm fine with this.
When you suggested it,
Arbitrary strike. মই 5-6 নাই।
heard Mr. Y.S. Manan, learned counsel for the petitioner, also heard Mr. K. Bashir, learned additional public prosecutor. Learned additional public prosecutor has prayed for some more time for informing this court regarding the fact as to whether any authority letter as mentioned in GD number 796 dated 26/2012 is there, and also if it is there, to produce a copy thereof. Learned Counsel is also, Learned Additional Public Prosecutor is also requested to inform this court as to whether if the search operation in the instant case was conducted after sunset,
After sunset.
then whether any reasons were recorded for conducting such a search after sunset.
That, your lordship, they have already verified the record, it's not there. That part they have already, only the authority letter was the issue.
No, assuming that authority letter comes, still
If it-
that is, even if in the,
No.
even you have to clarify on this point also for next date.
Yeah.
Suppose authority letter is there, authorization to conduct search is there, whether still the reasons has
Have to
to be recorded on.
Why it will have to be conducted after?
Because unless you mention that in the authority letter, or no, what is the mandate of the law? That is my
Yes.
query. Whether that reason is mandated, even if authorization is there.
That part is, that will come only if there is an authority.
Oh.
That is why, because otherwise what I was arguing was that there was no authority letter. So they have just, because the person
No,
was arrested. in
without
num-
authority also, there can be a search.
There can be a search, but this then in as per 42 proviso, second proviso, they have to give their reasons. in
Yes.
writing.
My
writing.
query is that whether that reason is still be required, even if there is an authority. Even if authorization is there, whether still that
Reason is
reason
required.
is required or not.
That is there, that will be subsequent. But
Mm.
what, after the GD letter which they read, after going through that letter myself, I found it was not the letter for search and seizure. It was a letter with regard to conducting a particular, arresting a particular person.
That answer,
They will have to give
okay. Let this case be listed again on
7th.
of February,
7.
as part of that.
Yes. Obliged.
Much.
May I please, honorable court, Mirror, in this,
How much time you will you
it
be
will
able
take
to,
most of the day, Mirror. My lordship had asked for judgments,
you
but
have
my lordship
45
would
minutes.
recollect that the point was I was named as an accused.
You have to refresh again.
My lord,
I have
I was named as an accused in the PRC charge sheet preferred by the police in 2019, where they said that though I'm named as an accused, no sufficient evidence was found to charge sheet me. That was the question before my lordship. And according to them, under 173
No,
subsection 8
here,
KRPC,
let me put queries. Here you have challenged the charge sheet.
no.
You are there.
Let me bring my lordship firstly to some basic facts. My lordship would understand it in a systematic way. In the year 2006, 2007, I was a public servant as attached to the circle office Dispur.
Okay.
Prior to that, the governor had sent 3 letters to the DC saying that you regularize this land in the name of a particular private individual company. So when the file came up to me, I had mentioned in the file that I do not have the authority to settle this matter on the Dag and Patta and settlement. Let it be put up to the DC. Then I was transferred out because of some games were there, my lord, that year there was some national game. Also, I was transferred to the GMC. So this matter carried on like that. And in the year 2018 or 19, my lord, there was a FIR file. There was an FIR file, my lord. Where's the list of systematic? So what happened, my lord, was that Gorchuk PS case 128 or 19 was filed by Mr. Dulal Bora. And this was followed by a letter from an officer in the government to register ACB case in the year 2019. So in 2019, these cases were registered on 3rd March 2019 in Gorchuk and on 20th May 2019 in the
Gorchuk PS
ACB.
case number reference is?
Miller.
Gorchuk PS case number 120.
ACB PS case 7 by 19 dated 20th May 2019 under section 119, 120B, 167, 420, 468, 471 IPC, read with 13(1)(a) of the PC Act 2018. So one of the objections I took was Gorchuk PS case, which was filed by Mr. Dulal Bora. This court in division bench held that this gentleman was in the habit of filing frivolous cases against government servants and threatening them. And I put that also, my lord, as part of my petition. So that case has anyway been merged with the ACB case. So PRC.
Now there is only one case.
Now there is one case, my lord, out of which PRC 1551 of 2021 was filed on 31st July 2021.
After completion of.
My lord, and it was shown as charge sheet number 3/2019, dated 6th July 2019 under section 119, 120B, the same sections as the ACB case, my lord.
So
So,
you are challenging the charge sheet.
my lord, in the charge sheet, they mentioned that there is no sufficient evidence against me from 2007 or when the alleged offence was supposed to have taken place.
Then
The
what is
F-
your grievance?
The grievance was, my lord, as the Supreme Court has, I'll place the judgment before my lord in systematic manner.
Okay.
The long gap between the filing of the FIR and the alleged offence. And in between, as my lordship knows, there are so many other circle officers in between. Now, when I applied under the RTI provisions, let me inspect the file and see what offence that you have claimed against me. What is the document? They said there is no such file in the DC's office. It's missing. So how did the IO prefer to place me as an accused? And if my lordship, very recently the Supreme Court has held, I'll give
No,
my lordship the judgment also.
Before coming to law, let us.
On
be
facts,
clear.
my lord, it'll have to be jumping between facts and law.
No,
Because
your submission is that in ACB PS
yes,
case number,
no evidence is found against me. I could not have been held as an accused.
but your name has been.
I've been
shown.
named as an accused and no sufficient evidence. And in the same charge sheet, no permission has been taken to continue the evidence to file a supplementary charge sheet. That is also a
So
point, my lord.
in the supplementary charge sheet, you are named.
There is no supplementary charge sheet. There is no permission to continue the investigation. No permission has been granted to continue the investigation by the supervising SP. He simply writes that the investigating officer has retired.
Thereafter,
Thereafter, no supplementary investigation is carried on.
no.
So I'm left hanging. I don't know. I'm due for retirement honorably from government service in the month of November this year. Why should I have this sword of Damocles hanging over my head? Why should they have a stigma?
I have not gone through records.
My lord, that's why I'm
The-
orally submitting, because we may not have enough time to lead my lordship line by line through the record.
If required, we may spill it over to one, but
I am absolutely
because
with
it
my
is
lord.
part-heard matter,
I am absolutely with
The-
my
the
lordship.
charge
I'll be
sheet-
willing
the
to,
charge-
I'll be willing to convince my lordship that on the law, you cannot place me as an accused without further investigation. And if sufficient time has been given for further investigation, no further evidence has been found against me, I cannot be held as an accused. That is the law in short, my lord. The delay in the FIR is another point to agitate before my lordship. In fact, if my lordship, when I will take my lordship line by line through the charge sheet, the opinion of the IO is the basis for his writing that there is no sufficient evidence. In 2019, when the
if there is no
case was,
sufficient evidence,
in
then,
2019,
then on what is the recommendation? You are set
lord,
up for trial or not sent?
I don't know, because there is no summons issued to me, there is no warrant
No.
issued to me, nothing has been
After
issued.
going through the charge sheet?
After going through the charge sheet, nothing. The court has taken no action against me, but I want my name out of any criminal proceedings.
Where is the charge sheet?
Charge sheet, my lord, would find at page 35 of my petition. It starts at page 35, final form report, and I'll take my lordship to, I'll take my lordship to page 44. Column 11. halfway down the page, my lord.
But you are not charge sheeted.
Particularly the accused not charge sheeted, suspected, accused number 1. Accused number 1, my lordship may kindly note. So and so myself, then my lordship would come to page 45. If my lordship would come halfway down the line to sub-column 18 in Roman 18, any other important remark that is before the word accused number 3, other important remark for not charge sheeting, if evidence is insufficient, then again up in regard to me, any other remark not charge sheeting, evidence insufficient on top of second column on top of the page, my lord. That is for me. Then I take my lordship further. The brief facts as made out by the IO is at page 50. That would be in column 16 of the charge sheet.
Page number 50.
My lordship has noted down at page 40. Lordship has noted down at page 45 on top. Any other important remark for not charge sheeting, evidence insufficient? On top,
Yes.
my lordship is that is a reflection to me on the top second that's sub column 18
18.
above accused number 2. I am shown as accused number 1. Now at page 51, my lord. The
No,
running page
no,
51, internal page
before,
17.
Uh,
Mr. Chaudhary,
My lord.
before going into deep in the case, on perusal of the charge sheet, it appears that though originally your name was there somewhere, but after investigation, no evidence was found against you.
My lordship, I'm
Then,
absolutely hit.
Therefore, you are not charge sheeted.
No, my lordship, please come further. Please come further. At page 52, the allegation against me, 17 point B2, column 17.B2. Is my lordship with me?
Yes.
May I follow my lordship's pencil? It also appears from the seized documents of the DC Kamrup M that Srimati Kavita Dekar, the attached officer, had located forwarded the land sale permission of 2 biga of land covered by Dag number 91 so and so submitted by accused and so and so purchaser with supporting documents. Now my lordship would find in the entire charge sheet, this seized document of DC's court is not reflected in any seizure list. I don't know where the IO has come to the fact of seized documents. I had applied under the RTI saying that, can I have a copy? And I've been told that no such file exists. It's a travesty of justice, my lord, which is why I'm knocking on the doors of this honorable court. Now, my lordship would further come to page 56.
Yes.
At sub 17, column 17.L, internal page 32, running page 56. Let us see what they are saying about the concerned Lat Mandal. On investigation that even though the concerned Lat Mandal Ainul Haq mentioned in the prescribed column Assam Sarkar or etc. dated 6th of June 2005. No Situr Hukum Mote Patan Homi. I mean, it's in Assamese, in colloquial Assamese, my lord. But there is no such document. Where is the investigating officer got this from? My friend would be pleased to produce the document. Then what is the opinion of the IO? Yet, myself, The then attached circle officer, Dispute Revenue Circle, passed no remark on specific column of circle officer and simply forwarded the matter to the office of the DC Kamrup M for necessary action. What wrong have I done? Now he comes to his vision as a investigating officer as to what a revenue official should do. If the said CO, circle officer, passed specific remark regarding condition pertaining to the transfer of newly settled land as imposed by the government, probably the seller would not have been able to manage the officers of the DC's office. Is this anything to put an allegation against me? Where is the governor's letter? He made that. Governor's letter. Now, my lord, just for a moment. Where is the governor? This one? Where is the letter? Three letters. You didn't make photocopy. For a moment, my lord. What I found from the scanned copy of the lower court record with my lordship's record. This is what I found. Sorry, wrong. Wrong one. Sorry. You have a
Yes.
copy for him? No. This is list of Reliance. This is list of Reliance. No. Copy with me. Now, my lord. If my lordship will see, I have tried to make out a small content of document. Government of Assam letter bearing number so-and-so dated 6th May 2005 from Joint Secretary Government of Assam Revenue Settlement Department to DC Kamrup. The letter is from the Governor of Assam's office. Was pleased to order for settlement of VGR, village grazing land measuring 4 bighas covered by Dag number 91 of village Betkuchi under Beltola Moza with any agricultural seed farm and research center. My lordship would find that in the LCR at page 42, 65 and 32 or 5 of the LCR is written. There are three numbers of pages, my lord. So the pagination was not done by the staff, my lord. So whatever I could find the numbers, I've attached those particular letters of settlement to my lordship, the slip that I've given. Now the second letter is also dated Government of Assam number RSS 586 2003 dated 14th of December 2005 from the same officer to the DC Kamrup, where the Governor of Assam was pleased to order for settlement of land measuring 3 bigha covered by Dag number so-and-so to so-and-so, that the page numbers I've given. The third letter, my lord, is from the government of Assam dated 25th April 06. After I was no longer in the department, Governor of Assam was pleased to order for settlement of Sarkari land measuring 3 bigha 2 katha 15 lessa covered by Dag number so-and-so village Betkuchi under Beltola Moza from Nilachal. So thereafter in 2018, an IS officer, Mr. Rajesh Prasad, wrote a letter of complaint referring to these 3 letters, saying that Sarkari land has been settled in the name of a private party. So wherever I disobeyed orders or I have given some opinion or I ought to have done something, letter was to my boss, the DC Kamrup, but from the Revenue Settlement Joint Secretary, Government of Assam Revenue Settlement Department. So what I have pointed out at page 56 in column 17L, where the IO has said no specific remark by me and simply forwarded the matter to the office of the DC for necessary action. What have I done wrong? Can the IO then speculate and say, if the circle officer had passed specific remark, can I go against a senior officer's letter? I'm passing it on to another senior.
Apart from 17 point,
My lord,
for-
then my lordship would come to page 57. Internal page would be 23, that is at 17Q. 17Q, the summation by the investigating officer. He says evidence collected against the suspect officer and others are there at point 17L, 17M, 17N and 17O. If my lordship's pencil I'm following,
Yes, yes.
have been analyzed at this directorate, and it was decided that the evidence collected so far against the above mentioned SOs are not prosecutable evidence, and efforts may continue against the above named government servants.
Efforts to what?
To what is in his own mind, my lord, he's taken it with him to his retirement. And as a matter of fact, on discreet inquiry, I found after his retirement, he joined the office of the other complainant, Dulal Bora, in an informal capacity and helping him with so many things, my lord. I've mentioned that in my petition also. Now, my lordship would see page 24 internal, page 58 running.
It implies in 17.q that evidence is not there and
Nothing. Now, my lordship would
further
see further.
investigation was recommended.
My lordship would
But
see
in-
further. He has tried to justify it under the law.
Yes.
That is where my lordship is to interfere. Page 58, internal page 24. In the instant case, the government servant, namely so-and-so, large so-and-so, and there's number 5, there's another person, Bhaskar Chetri, who was arrested and his 164 statement has been recorded and kept in seal cover. Could not be forwarded at this stage for standing trial. However, efforts are on to collect credible evidence against them. What does he mean by credible evidence? Prima facie evidence is the only term that should be there if you want to continue the case. In view of the above, investigation will be continued as per provision of section 173(8) CRPC to collect further evidence against so-and-so. Where is the permission here to continue the investigation? Nowhere at the bottom. My lordship would turn next page, which is page 25, internal, and page 59 running. At column 21, it's nil for the Honorable Court to discharge accused persons under provision of CRPC under section 160, if any. 22. Therefore, prayed that the Honorable Court may take cognizance of the offences committed by the accused person as mentioned in para 18 above. I'm included in para 17. And issue processes against the accused person to stand trial in court in the accordance with law. Where is the...
You are not in para 18.
No, but I am on the grievance that, where is the investigation being allowed to be continued? Can you keep me in suspension? There is no investigation to
No.
continue. You put me in the charge
What
sheet.
I understand till now, that during investigation, nothing was found
Then
against
discharge
you
me.
to.
Then
But
say there is no
they are
evidence.
in a hope that they may collect evidence against you, and
What is
therefore
hope, my lord? Investigation is never hope. Investigation is
No,
solid.
no. I am
Investigation
not coming
step
to
by
a
step.
conclusion. I am not coming to a conclusion. I'm just from what you have read till now.
Yes, my lord.
The charge sheet says that the investigating officer could not collect materials so as
Against
to
me.
justify a trial.
And he's asking for
But he is
continuing.
asking for continuance of the investigation.
And no continuance has been given because in these columns it should have been given by the superintendent of police who signed it. Nowhere has he given it.
Okay, now what is the submission?
Solution is
But
that
you are aggrieved
I am aggrieved, my lord.
from the fact that
Is there a
in
note?
spite of an investigation after laying of the charge sheet,
My lord,
investigation is continuing against you.
whether it's continuing or not continuing, I don't know, because when I tried on my level under the RTI Act, I'm informed that there is no such file in the DC's office or with the police. So what are they investigating, my lord? My lordship has no file before him, and we are arguing the case with nothing. It is similar to that. When there is no file, what are you investigating? How are you saying there is a seized document when there is no seized document in the record, scanned record before my lordship? Even in the list of documents filed with the charge sheet, there is nothing.
Now, whether in this case, case diary was called for?
Case diary was never called. I never applied for bail. This is a charge sheet.
No.
The case diary came to a logical
Because
end when
you
the
are
charge
not,
sheet.
you are not against the charge sheet. You are against the.
I'm against the very fact that there is an FIR where my name has been mentioned, certain sections have been written against me in the FIR on the basis of the informant. Subsequently, there has been no evidence found against me. So why am I charged under PC Act under so many sections of the IPC? For what reason am I being listed as an accused number 1, but not charge sheeted in view of insufficient evidence? I have here a plethora of judgments, my lord.
What it says.
I'll bring my lordship to it.
Now, what relief you are seeking?
I am seeking that any FIR against me should be quashed because of the same.
Which FIR?
FIR is the ACB PS case 7 of 19,
Okay,
dated 28th May 2019.
let us see where your prayer portion,
My lord.
where have you prayed for that?
My lord. Specifically, I've asked for quashing also in the revision petitioner in the charge sheet. Certain columns are mentioned in page 26 of my petition. Page 26,
Yes.
prayer. It's on third line. Set aside 1, aside, cancel, expunge, and quash the name of the revision petition in charge sheet number 321 dated 6 July, where at page 10 or 25 at column number 11 title is particular of accused person not charge sheet listed subserial 1 at page 10 or 25 as accused number 1, where at subserial, am I going too fast, my lord?
No, no.
At subserial 2 at page 10 of 25 as subserial 17 at page 11 or 25 in the name and other details, the present revision petitioner, including a status not arrested, is shown and listed subserial 18 of column number 11 at page 11 of 25 under this heading, any other important remark for not charge sheeting, evidence insufficient, with charge sheet arising from ACB PS case number so-and-so, 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 corresponding to corresponding so-and-so. IOS failed, page 27, my lord. IOS failed to produce any evidence or material evidence against the revision petition. Therefore, it was appropriate to quash a name from the case and allow the proceedings to continue in the manner prescribed by law and exercise power conferred in this section. Let the case continue against the other accused who are named. When and if the prosecution or
Which
investigation,
case? Which case you want to quash?
the ACB case, my lord, because both the cases are merged. There is no Gorchuk PS case anymore.
Now, in ACB case, on the basis of ACB case, the PRC case number 15.
Has arisen.
Now
Precisely.
PRC case number is proceeding in the court.
It's
What is the
there,
stage?
there is the stage, my lord. The accused have also not appeared.
It is the
They
stage of
they're just
appearance.
giving dates, my lord.
At the stage, in the stage of appearance.
Appearance, my lord. They're just giving dates.
And
The
there
next
the
date-
question of issuing notices to you does not arise.
I found a mention in the order sheet in the scanned copy of the record where my name has been mentioned there, but no summons, nothing has been issued to me.
What has been mentioned?
Exact words, my lord. What was mentioned against us? The scanned copy.
Which order dated?
No, in the certified copy which I applied for, I've got only 2 copies of the order. That is till 12th of August 2021. So I'll have to look at my lordship's record and then mark it for my lordship.
It is.
I applied for the certified copy and I can't, Can my friend help me with the dates? To be 7th of
7th
September
2021.
2021. 2021, I was.
Date of order is 19/9/2020.
My lord,
You want this
scanned copy of the low court record.
scan copy? to the-
The scanned copy came much later than my certified copy.
Okay. Which order you were referring to? Order dated?
I'm just bringing my lordship to that. I'm sorry for. Is that the latest judgment that we put out? No, judgment. Today's judgment will be photocopy. This is the judgment I found, sorry, not this one here. The Sushil Suri is referred to in that. What's the other judgment which we pulled out today? That was the one I needed. Today I had found a judgment on live law, my lord, and then I came. I tried to download it. My computer skills are not as good as my learned friends here, so I was unable to print it. My lord, that order which my name has been mentioned doesn't appear to have been sent from the lower court.
No,
I saw it in the lower
certified
court.
copy is there with you.
Certified copy
You may
of
read it out.
2021.
What is there? I want to know, is there anything
Yes,
which has aggrieved you?
yes, my lord. You have a pen? Thank you.
You have to tell me two things
My lord,
after that.
my lord.
What exact relief are you seeking?
My name may be struck off the FIR, my lord. And since I'm not having any sufficient evidence against myself in the charge sheet, there's no reason for any materials to be found at this stage when all the files are missing. The investigating officer or the prosecution branch should actually find out what has happened to the file after they find the materials, my lord. If they feel it's sufficient to file a proper supplementary charge sheet against me, I have no grievance. But right at this stage, when they are saying that there is no sufficient evidence, why keep me in a charge sheet before the court when I should have been struck off as an accused? I should not have been placed in this charge sheet at all if there is no sufficient evidence. It's
No, suppose somebody names you in the FIR
my lord.
and then investigating officer conducts an investigation.
Yes, my lord.
After that, he does not find anything against you.
Yes, my lord.
Then your name has to be mentioned in the charge sheet,
And
telling that nothing could be collected during the investigation. Therefore, he is not
not an accused. That is the exact word, that he is not an accused. If my lordship would recollect any other charge sheet, they always write this. But how can you continue to keep me as an accused number one
No, not sent up for trial. You are not sent up for trial. You
But
were,
investigation is to continue, but
That
not
may
sent
be
up
an-
for trial. That means the court below should also not be listing me in their records. If as an investigating officer under the CRPC and under the Police Act, which is applicable to the Assam Police, if my friend is not an accused, I cannot have his name before the court. I simply have to close it in the charge sheet.
yes,
That is the same law in Punjab. I've annexed a few Supreme Court judgments on that, my lord.
yes.
You cannot keep me in the charge sheet. It is stigmatic. I am still in service.
But somewhere in the charge sheet, there has to be a mention that he was originally an accused, named accused in the FIR.
Yes, they can
the
write
conduct-
that. He was named as a accused in the Ejahar. I have
Oh.
marked that also in the complaint. I marked that in the complaint on the 2 pages where it's been seen. And then that this has not been mentioned in the charge sheet.
Your one grievance is that the endorsement by the IO that they will be collecting credible evidence against you.
Yes.
So.
I mean, as my lordship would see, in all the judgments that I have studied, lordship might be knowing more than I do. I bow to my lordship's knowledge. This kind of a statement does not find reflection in the court of law.
Okay.
What do you mean that you're going to keep finding credible evidence? There's no time limit. There is no, it is a forever kind of basis. From 2006, 2007 to 2019, you could find nothing. I am to retire in 2024. You'll keep finding it till my death. If my lordship would recollect this court itself in Bhagya Kalita's case, sent the matter back to the trial court saying that the evidence has vanished, the evidence is not credible enough to have a sentencing and conviction of the accused, main accused. So what did my learned friend in the court below say? That he has no credible evidence found in the record. It is only the superior court up there that can convict so and so. That was the wording in our own court, my lord. That is why I am aggrieved. Because this stigma to an honorable person will last forever. It may even affect, if I go to a social function, they'll say, my friend has a criminal case, his name is, he is an accused. What will an ordinary person in society understand? If I go with a marriage proposal for my child, or criminal case is pending against so-and-so, his name is there in the accused in the charge sheet. The court is also searching for credible evidence. The social stigmata. The Criminal Procedure Code does not allow social stigmata. This court has in many cases interfered, my lord, when there is such similar situations. There's one more judgment, my lord, which I found. Have you got the Supreme Court reference? You don't have that also. One more judgment is there. I'll have to give it to the.
No, what I propose,
My lord.
Mr. Busho, you have to answer
Lordship.
what I propose, because today we don't have time.
My lord.
If you are clear with the facts,
My lord.
on law points, you may submit on the next day,
My lord.
which we will fix a short date,
My lord.
so that
My lord.
everything remain
My lord.
fresh.
Fresh, my lord. In live law, I found, my lord, which will be for interest to my lordship. A magistrate can't take cognizance of a supplementary charge sheet if it lacks fresh evidence after further investigation. The Supreme Court said this in. Can you open
Yes,
it?
yes, but
My lord,
in your case, no supplementary charge sheet has been.
no
yet
fresh
given.
evidence has been found either. Forget about the supplementary charge sheet. Where's the fresh evidence? Have I been examined further to my original 161 statement where I explain in detail how the revenue branch works? That is not even found mentioned in the charge sheet. Revenue branch, my lord, works in a very mysterious way. A circle officer who is attached cannot take a decision to settle land, even if a joint secretary of the revenue department directs the DC Kamrup. The charged officer, circle officer attached, suspected officer, SO, will have to put it up to the DC. And that is what the Ainul Haq that Lat Mandal has said. Where is that document? This IO has written something, there is no document to support his statement. He says from seized document, I'm looking for a seized document. Then he says there is no sufficient evidence. So and so is not accused of the allegations as mentioned in the Ejahar. Let me go free of any stigmata. After all, the law, as your lordship knows it far better than I do, will not allow me to have a stigma. Assuming I've been in service for more than half a century, a quarter of a century, say about 30 years plus, why should I, in the fag end of my career, go out with a slur? I have done nothing wrong. One IO who is retired has written something, filed it in a charge sheet and then gone and retired. He's closed the door. And his superior officer has not looked at the charge sheet. He simply blindly signed it. As far as my experience goes, my friend can tell me more as being the officer of the government in this case. The supervising officer who is superintendent of police over the investigating officer, he has to carefully scrutinize the PRC and the charge sheet before it is filed. Any credible mistakes that are on record is the duty of the supervising officer. Especially since it's a case also where there is a section under the PC Act. The old PC Act of 2018 as amended by the time this charge sheet was filed. My lordship knows that there is a specific officer earmarked in the Act to supervise the investigating officer. DYSP, I think, is mentioned over there, and the superintendent of the police is the supervising officer in a PC Act case. Then section 197 of the CRPC provides for sanction for prosecution. My lordship knows very well, if it is within the charter of my duties, sanction for prosecution is to be taken. If it is outside my charter of duties, I've done something not within the charter of my duties, he does not need sanction to prosecute me. That is also not mentioned in the charge sheet, whether I have done according to the government laws, charter of duties prescribed.
The question of sanction does not arise now because
Even for
Nothing was
investigation, my
nothing.
lord. Even for investigation, if they are coming to the DC's office, when they are coming, they have to take permission from the DC since the revenue, joint secretary, revenue, governor, nobody has been made a party for their letters, which are directing for settlement of the land in the name of a private party. How am I, a little cog in the big machine, being held responsible?
Okay, so
Let the governor be sanctioned for prosecution. He is the one who issued the letter through a joint secretary of the revenue settlement. Government of Assam letterhead and all that. Their certified photocopies are placed. I've got the certified copies here. From the records of the scanned copies of the records come from the lower court. Some application of mine should have been placed. Unnecessarily 451 Mandal, some other ACS, 2-3 other ACS officers have been named. Where is the joint secretary who has issued the letter? He's not been named as an accused.
no, Mr. Chaudhary, what I have understood that in this case, though certain allegations were made against some officers of revenue department, during investigation, sufficient materials could not be collected against you. Therefore, you are shown
As
as an accused,
not judged.
not sent up for trial.
But one thing is there, the 3 letters from the Department of Revenue for that period, 2005, 2006.
Yes.
How come
No.
that has not been, that has been mentioned by in the Ejahar filed by
No, let me complete.
Milord.
Not sent up for trial.
Right.
And an endorsement by the investigating officer has been made that which they have used different language, but
Yes.
which means that they want to continue with the further investigation against you.
You continue, my lord, I have nothing against that. You continue, I'm not interfering in the investigation. What I
Now-
am saying is in my materials placed before my lordship, I have at page,
No,
84.
we are not going now.
I'm saying that under RTI, when I asked for the copy of these documents, which are supposed to be against me, they said there is no file. That doesn't form part of the
No,
investigation.
this you have already stated.
My lord,
Now, on the next day, you have to, we'll fix the further hearing on the next
my lord.
date.
And the judgments which I have given my lordships, I'll take my lordships through them
Ah, yes.
on the point of law.
And you have to specifically mention.
I've mentioned the paragraphs involved, my lord.
No, the relief, specific relief, because the prayer portion is not very clear.
Criminal law, my lord, do we have to have specific relief?
No, that, on that also you may
I can make a submission at
make
the
a
bar, my lord.
submission, make it
I'll
submission.
make a submission at the bar.
That even if specific prayer can be molded
My lord.
to that regard also you may make your
Because
submission.
as far as I can understand what my lordship is saying, like we have in the civil proceedings, I make an exact prayer.
No, I am
but
not
under-
saying that
under
exact prayer
482
is required. What I am saying that what relief you
My lord.
specifically want, you have to inform this.
I'll inform my lord.
So, and you make your part of submission on the next date fixed.
My lord.
Now, what is the information regarding, is there further investigation going on?
So that I have to take the instruction because earlier the matter was Padhat and learned EPP RR Borua.
You seek that
Yes.
instruction.
Yes. And
Or-
discuss with
orally.
him also. Today actually
You can inform this court orally whether actually any further
investigation is going on or not.
Without interrupting
Because
my
they-
lordship, perhaps they should ask the SP.
There, oh,
The SP should be asked of this
or I will
anti-corruption
pass,
branch.
I will
Yes,
pass
yes,
an order.
that will be better. If Lordship may.
Because
direct.
how will my friend at the bar and his other friend at the bar be able to inform my lordship exactly what
Okay,
the
heard-
SP is supposed to say?
Heard Mr. P. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Bashaw,
K. Bush.
K. Bashaw, learned additional public prosecutor. Hearing remained inconclusive. Let this matter be listed again on, when do you want?
My lord, it's a good day. 8th of
8th,
February.
8th February. Let this matter be listed again on 8th February.
Huh?
As
No, my lord, I'll change it.
it would be convenient for me.
On 6th February, my lord.
8th would be good if.
6th, my lord. 8th, I'm a witness in my own case, my lord.
Okay.
It's in this court only. Yeah. 6th, my lord, it's convenient to my lordship.
Six,
Mr.
actually,
Fine.
we may fix, but
Yes,
we
we
may
can.
not get much time.
Yes. Yes, we
Because
can
what
do it.
happens, my lord, is on 8th, my lord, I would be.
Okay, let us fix on 6th. Let us see. On 6th of February,
Yes, we can instruction of the department and
the
Like, जल्दी करो, मुझे एक
learned
body का sign.
additional public prosecutor is requested to inform this court on the next date fix as to whether any further investigation is on in
Respect of the
respect
petitioner.
of ACBPS case number 7/2019
Against the petitioner, my lord. I'm only sticking to my prayer. I'm not
against
sticking to the.
against the present petitioner, namely Srimati Kavita Deka. And let this court know about the status of the said investigation.
Copy of the order may be given to my friend.
Let a copy of this order may be furnished to learned additional public prosecutor so that he can procure this information. Let this case be accordingly listed on 6th of February.
Just as an aside, my lord, not anymore. As my lordship has been hearing number of bails regarding illegal land settlements. So the ACB is well aware of who is the accused, who is not the accused, what is the investigations. Continuously, there's been various allegations against the revenue branch. I have been hearing, sitting and hearing my lordship giving bail orders in 99 bails, I think, before my lordship regarding the.
But lordship, here what I understand, here the petitioner, she was the cycle officer,
Yes.
but from where the process was made
No,
regarding that.
it doesn't start
And,
with the
and the
circle.
allegation was made by the complaint was made by the principal secretary revenue himself that time
Okay.
My friend-
No,
regarding the allotment.
what is important is your relief which you are seeking.
And what is also
Because-
important is my friend remembers that the letter from the Joint Secretary Revenue Department came to the DC. And I was a cog in the DC's office where it has to come to my branch. I cannot initiate as he's suggesting.
You may be aggrieved by the fact that any further investigation is on. If it is for inordinate
Delay.
since long it is pending.
my lord.
So there may be a question before the court that how long further investigation may continue,
My lord.
if it is in fact continuing.
And whether they have actually traced the record, because I've placed the reply from the DC that no such record is available.
Okay.
So,
Okay,
I mean, I can't go and ask the DC where are the files vanished.
let us see what report Mr. Bashir brings.
Lordship.
I'm deeply obliged because when the DC office shifted and the circle office shifted,
On 8th, we will
Try to finish
take
it.
up this matter at
2 o'clock,
not 2,
fixed item.
as per the available rules.
Look, may it be a fixed item, my lord.
Yes, as a fixed item.
And I'll make a mention at 10:30 in my lordship's meetings. Obliged to my lordship.
It is 6 তারিখ হচ্ছে 6
Eight,
8 হলো না? 6
sixth